Welcome back to the Emily Show. This week I'm back from travel and we are back talking about Diddy. Has your social media feed been just covered with resurfaced interviews, videos, photos? Because in the brief amount of time I've been on social in between traveling, mine has been overwhelmed with it. We're going to talk a little bit about that, but mostly what his attorneys continue to argue for his release. Bail was denied again. And we didn't get to cover his motion to dismiss in the Little Rod lawsuit, but we are going to take a look at their argument in that lawsuit and see how well it's aged. Plus, I have some updates on all the other ongoing civil lawsuits, what they mean. And there's been a ton of questions surrounding this case, the videos the feds have, and what can come next. We're going to talk about that too. So let's get into today's episode. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Now that kids are back in school, maybe it's time to pay a little bit more attention to you, or maybe you're not pausing in your day to make yourself something for lunch, don't always have time to make something for dinner. I use Factor meals to supplement the middle of the day, especially on long work days and when I'm covering trials, because I don't have not only the bandwidth, but also the time to even put together the ingredients in my fridge, which makes Factor the perfect option for me during those busy times because the meals are dietitian approved and delicious and ready in just about 2 minutes. Plus, they have premium ingredients like filet mignon, blackened salmon, and shrimp, so you're not just eating chicken and chicken and chicken. You can choose from over 35 different meals in case you very much like chicken, and there are more than 60 add-ons, which means you can supplement snacks or even breakfast. Plus, with no shopping, no prepping, and no cleaning up, it is the perfect option for when you want something healthy, delicious, and on the go. So if you're ready to make life a little bit easier, head to factormeals.com/EDB50 and use code EDB50 to get 50% off your first box plus 20% off your next month. That's code EDB50 at factormeals.com/EDB50. 50% off your first month and 20% off your next month while your subscription is active. Let's get back to today's episode. First, we're going to take a look at Diddy Nostradamus in his own words about the fact that he thought his parties would be shut down and that they'd probably try to arrest him over his parties, telling an interviewer from ET in 1999 that he was just trying to open people's eyes. And let's just take a quick look at that because I think it may be somewhat illuminating. The interviewer says to him, "Your parties are the hottest ticket around." And he said, "They won't even give me a permit for the parties." Can you imagine?
Me a permit for the parties, man. They don't want me to throw the parties no more. But we ain't gonna stop. We're gonna keep on having fun, bringing people together from all walks of life. You're gonna hear about my parties. They're gonna be shutting them down. They're gonna probably be arresting me, doing all.
You're going to hear about my parties. They're going to be shutting them down. They're even going to be arresting me. We definitely have heard more about these parties than I think most of us ever wanted to.
All types of crazy things just because we want to have a good time. You know, whenever you bring up a different.
I don't think your definition of the word "we" is the same as a lot of the people at the parties. Because you say we want to have a good time. I think what you mean is you want to have a good time. And there were others that really didn't want to be participating.
Element into people's environment, things that broaden people's horizon. People get intimidated. There's a lot of people out there that feel intimidated by it.
There's a lot of people out there that feel intimidated by it. So in his own words, they won't even give me a permit for the parties. I'm not shocked because what do you even say? And we're just trying to have a good time and broaden people's horizons. And they're just not ready for the kind of, I don't know, freaky that we want to get into. Well, you can get into whatever you want to get into if the people involved are consenting. But when it is by force or fraud or fear, then we step squarely into the territory of crimes. And for those crimes, there is a presumption that Diddy stays in custody. We talked about this on last week's podcast at the first very extended detention hearing. The day after, there was a second detention hearing, and the judge also denied that request for release. But the defense filed a new letter to release Diddy. The prosecution filed a new response to it. And we're going to take a look at those before we take a look at what's going on in these civil lawsuits. And then, maybe we need to talk about the fact that over the weekend, people deleted their entire Twitters all seemingly out of the blue. And when are we going to hear from J-Lo? I mean, they were engaged during the late 90s, early 2000s, and a lot of this seems to be alleged to have been going on during that period of time. So has J-Lo talked to the feds? Is J-Lo going to say anything? Are we going to see things deleted, removed? What else is going to come forward from all of this? And I don't think that the deleted Twitters of Usher and others have anything to do with the federal investigation. If the feds want to get to your Twitter, or your X account or whatever. If I say the feds want to get to your X, it feels like I'm talking about something else, like an ex-partner or spouse or X marks a spot. I don't know. I just can't. It's the social media platform formerly known as Twitter. So when the feds go to get that information, if they ever wanted it, it would just be subpoenaed. It would still be there. I think it's because the public is now digging so much into connections that Diddy had, who he was spending time with, who was spending time at his parties, who was under his wing, who was, it's weird to call it mentoring at this point after everything that's come to light, but whose careers did he have a substantial impact on? And I think that's why we're seeing some deleting their Twitters as, again, the public wants to take a closer look at everything. And you know what we're going to continue to take a closer look at? The court documents. That's exactly right. Quick, Emily, things you love and hate about federal court. Well, in New York, it's a pretty easy standard process, but also they do these letter filings that are all single spaced and they're not on legal paper, and they make it so hard to read. I hate it. Can we not single space? Most courts do not. Can we stop with the letter file? Why is this the rule in New York? I don't know, but I don't love it. Going first to the letter from the defense, it is 124 pages long, but most of that is attachments that relate to the house in Miami that Diddy very much wanted to secure his freedom, so he was not being held in federal detention. It did not work. But let's see what the second bite at the apple looked like for the defense. Dear Judge Carter, Mr. Sean Combs, through his counsel, submits this letter in lieu of a formal motion for Mr. Combs' release from custody on the proposed bail package below, as set forth the defendant's updated bail package. And then in parentheses, it says updated even from yesterday's filing. And then there's a footnote. Footnote is, we are mindful that we are giving the court a substantial letter on the same day as the hearing and have endeavored to do so as early in the day as possible. We thank the court for its willingness to hear our application on short notice. Yes. We know it's a lot. We've dumped a lot on you, Your Honor. Please don't keep him in custody. They said the defendant's updated bail package addresses both risk of flight and danger to the community and reasonably ensures the defendant's return to court. The letter will walk the court through a series of actions taken by Mr. Combs over the past 6 months that we view as unprecedented and that prove he is not a risk of flight or a danger to anyone in the community. These actions show that Mr. Combs is eminently trustworthy. Sir, really? Okay. Eminently trustworthy, that he is demonstrably committed to showing his innocence in court in the context of this case, and that he should be released on the conditions proposed in order to do so. It is quite a lot of words. Every defendant, when they are in court, innocent until proven guilty. At the stage of bail, though, what the defense has left out of the SAT wordiness here is that the presumption in this case is that he remains in custody. And the first judge said the defense has not shifted that presumption, has not overcome the presumption of custody. So, what I would like to hear from the defense is how they are going to overcome the presumption of detention. And then they go on to state the things they stated before. Mr. Combs flew to New York on September 5th to surrender. The first thing the court should know is that when it became apparent to his counsel that Combs would at some point be formally charged, he did something extraordinary. He left his home in Miami and traveled to New York to surrender. We told the prosecutors he was in New York to surrender. We asked them for a time for the surrender. They never got back to us. The government withheld this information solely so they could arrest Mr. Combs and not allow him to surrender, which he flew to New York to do. Well, they don't have to. The government can just, they can arrest you if they have cause to arrest you. And an indictment is cause to arrest. It goes on to say, nonetheless, that Mr. Combs traveled to New York to self-surrender is a major factor the court should consider. However, surrendering himself to the prosecutors was not the first action Combs took to show his trustworthiness and lack of flight risk. Indeed, it is part of a pattern. Well, I mean, the RICO charges are also part of a pattern, but go off. It is part of a pattern since even before the March 25th, 2024 searches on Mr. Combs' residence. He was aware that there was an investigation before the searches? Was that because of the Cassie civil lawsuit? Was that what kind of made him think that maybe this time he wasn't going to get away with anything? Maybe now was the time that the consequences of the actions might be felt? Please tell me more about what the pattern is from before the March raids on his home. They say that Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking and other offenses, knowing for these many months that he would be indicted. Tell me what you knew before March, because these attorneys said in the bail hearing, this is why attending court is so helpful to me, even when I don't always get to do it. But he said in the bail hearing that they were hired on in March, seemingly after the searches. So again, what was he doing before the searches? Because you said that in one sentence and then you haven't expanded on that thought. They go on to say, knowing for these many months he would be indicted. Everyone knew he was going to be indicted after those searches from HSI. We just wanted to know when. Combs has done everything, as will be set out below, to work with prosecutors in ways that are unusual, if not unprecedented. Well, that's not the only thing in this case that's unusual. I didn't think this was going to be a snark-filled reading, but I can't help myself on first view of some of this, and I wonder if the research attorneys are thinking the same thing. It goes on to say the law is clear that a district court reviews de novo a magistrate judge's decision to release or detain a defendant pending trial, and they cite the law for that. We respectfully submit that Mr. Combs can rebut the presumption. There it is. There's the standard. Rebut the presumption of detention here due to his extraordinary actions in this investigation. Okay. Tell me what he did in connection to the investigation that was extraordinary. Tell me what he did that wasn't solely to save his own ass from being in custody. I'm curious. It goes on to say he should be released on the conditions proposed so that he can fight this case in court effectively. He can also do that from custody. Unless your definition of effective involves Mr. Combs working the phones like it's a telethon, which is what the government has alleged he was doing leading up to his arrest and is a big part of why they wanted him to remain in custody so that he wasn't reaching out to victims, witnesses, and potential witnesses. The proposed bail package. The defense proposes the following bail package, not all of which were proposed as part of our package to the magistrate judge. Oh, Your Honor, it's new. We've bartered against ourselves and brought more to the table. These proposed conditions will assuage any fears of danger to the community and will ensure his return to court. a $50 million bond co-signed by Sean Combs, his mother, his sister, the mother of his oldest daughter, the mother of his youngest daughter, and his 3 adult sons. That's a lot of people. The footnote 2 says the mother of his 4 children is deceased. The internet has questions about that. His 3 adult sons and his sister will be present at today's hearing. Having family support is always important. It doesn't necessarily mean he won't flee and or that he won't be very active on the phones. They also say he would like to secure the $50 million bond by his residence at 2 West Star Island in Miami, Florida. And according to the internet, other notable residences of the famed Star Island are Emilio and Gloria Estefan, Enrique Iglesias, Don Johnson, Rosie O'Donnell, Shaquille O'Neal, Rick Ross, and Lisa Hochstein from Real Housewives of Miami. But at the top of all the Google searches for Star Island, of course, right now are Diddy. They said that in securing the $50 million bond by the residents, the appraised value of the home is $48 million, and they attached the appraisal. They said the home is unencumbered because he paid off the entirety of the mortgage, and that they attached that as well. The attorney said in anticipation of this bail hearing on August 20th, 2024, Combs paid off the remaining mortgage of about $18 million so the home could be used to secure a bond and be free of a mortgage. I wonder how much the lawyers are getting paid. It is also offering to secure the bond by the equity in Sean Combs's mother's home, and it said Combs' travel will be restricted to the Southern District of Florida and the Southern District of New York to attend court, meet with his counsel, and attend medical appointments, as well as to the Eastern District of New York or District of New Jersey, only to the extent that his travel to and from New York involves an airport in those districts. So they are saying, look, he will have travel restrictions. Most federal defendants do. We talked about this a lot in the Jen Shaw case, which was also out of the Southern District of New York, that she could be where she was in Utah or be in the Southern District of New York for court, and that was it. But let's continue on to see what is new. It said Combs's passport was surrendered to counsel on April 1st. His counsel advised the prosecutors of this fact in an email dated the same day. Counsel will provide the passports to pretrial services. It's not uncommon that those get turned over to pretrial services. It says the passports of the family members have been surrendered, which is unusual. I don't think I've seen anyone turn over their family members' passports. It's like, look, he can't travel with his family, though. If you're traveling on a private jet, you could probably arrange traveling without passport with some amount of wealth. It also says, the airplane again. Since at least April 2024, Combs has been making efforts to sell his airplane. We informed the government of these efforts in May 2024, as explained further below. Just last week, Combs entered into a letter of intent with a party to sell it. Combs understands he is not to travel to Los Angeles, where the plane has been located this week, and that the plane is not to be brought into any district in which he is located until it is sold. Footnote 6, it said, as of yesterday, the plane flew to Teterboro, New Jersey for a chartered flight. They're like, well, just in case the internet sleuths tracked the plane, he wasn't trying to get to the plane. Well, he was in jail, so it's not going to be too difficult to understand. He's not on the plane. He offered home detention with GPS monitoring. He offered to restrict all visitors to the residences at 2 Star Island and 1 Star Island, the adjoining property that he owns. Oh, he owns 2 properties. Except for family property caretakers and friends who are not considered to be co-conspirators. What about friends who are not considered to be co-conspirators, witnesses, victims? I think we need a broader definition. Anyway, restrict female visitors to Combs's residence except for family or mothers of his children, that the security company that secures his person and properties will require any person who enters the property to sign a visitor log, and then the company will produce these logs to pretrial services nightly. Footnote 7, it says, if the government and court prefer that Mr. Combs employ a different security company than the one he has used for the past decade or so, we request a week to engage a new security company to comply with this condition. Some of the allegations and predicate acts with regard to the RICO charge run up to the time of the indictment in September. So I don't know if the government's going to be satisfied that the security company is looking out for anyone other than Mr. Combs. No contact with known grand jury witnesses. Trial's going to have many more. Weekly drug testing by pretrial services. all other standard conditions of pretrial supervision. So they are offering essentially 24/7 surveillance, but they don't expressly say that. They're offering GPS monitoring. Again, it wasn't persuasive. I don't even know if terms that we see in digital crime cases, like no access to the internet, no electronic devices, no phones, no Wi-Fi connected TVs, I don't even know if those types of conditions would have helped here. It goes on to say that the history of this investigation shows a great degree of collaboration between the government, Combs, and his counsel, which should weigh heavily in this court releasing him on the conditions proposed. On March 13th, 2024, counsel for Combs emailed the assigned AUSA. In this introductory email, counsel identified himself as counsel for Combs and stated he wished to speak with the prosecutors and share information about Mr. Combs and the matters under investigation. So that was more than 10 days ahead of the searches of his residences. I wonder what tipped them off knowing that he would need to retain counsel before his homes were even searched. Obviously, they had to get a search warrant. I wonder who the feds spoke to where he knew that the feds were speaking to someone, or if he got a target letter. That could also be it. It says, after not hearing back from the AUSA's, counsel again emailed prosecutors on March 18th. Yeah, they don't care. It says counsel did not get a response to the second email. They're not going to comment on ongoing investigations. If there had been a target letter, I mean, maybe they would have resent the target letter. If there hadn't been, I'm not surprised that they didn't respond. But that's new information. It goes on to say on March 25th, search warrants were executed at Combs' residences in Miami and Los Angeles. In addition, he was removed from his airplane and searched. Oh, we've heard. The searches of the residences were unusually public and particularly heavy-handed. The agents had assault rifles trained on the heads and chests of his children, who were then handcuffed and brought before news cameras and a press helicopter. I think they were brought outside the residences, and there happened to also be news media there because the ongoing searches were happening. But this is a complaint of many federal searches that they are armed with assault rifles. That is not unusual to this case. Again, hearkening back to the Jen Shaw case, same federal district, home was searched, but she was arrested the same day the searches went down. But that was not a crime of violence. That was a wide-ranging fraud scheme. And the same things were in her motions, that there were assault rifles, that all the kids were brought out of the home. So this is not unusual, and this is not the searches on his homes being treated differently than any other searches by the federal government. It goes on to say on the day of the searches, counsel called the prosecutors and they spoke for the first time. Counsel indicated he would accept service of 2 grand jury subpoenas to Mr. Combs' businesses. They say counsel took possession of Combs' passport April 1st, which we've heard a lot about. Counsel agreed to advise the government of all domestic travel. Well, they were probably trying to put off when he was going to get arrested in this by making it seem that he was not a flight risk. They offered to say, hey, if he's traveling around the US, we'll let you know. And then they list out all of his travel. They go on to list again how much effort went into selling the plane and how impactful that should be. And the government's going to be like, okay, thank you. We're going to forfeit all of that money. They say that he voluntarily relocated to New York in advance of his arrest. Look, they would have arrested him in Miami or Los Angeles just the same they would have arrested him in New York. It probably would have been less comfortable travel from any of those locations to New York once he had been arrested. But that was his choice. The government didn't ask him to do that. They said that counsel offered continually to share Combs' location with the government. Since arriving in New York on September 6th, Combs has been staying at the Park Hyatt, New York, due to bookings made at the Park Hyatt prior to Combs' reservation. After September 17th, 2024, he would no longer be able to stay at the Park Hyatt. Accordingly, Combs had a reservation to stay at the Carlisle Hotel starting yesterday. Combs and counsel have also been looking for a short-term rental in New York City so he could reside here until the government made the determination as to whether they would charge him. Well, problem solved. They go on to say that they told the government that they took all the family passports, that they assisted the government concerning subpoenas. During the press conference with the U.S. attorney for the Southern District of New York, someone in the press corps asked, Defense counsel says Sean Combs has been cooperating. And the answer was to the effect of not obstructing justice isn't cooperating. It's basically what you're expected to do. So our definitions of cooperation are very different. Fulfilling legally required obligations is not falling under the government's definition of cooperation. But they say that defense counsel was very helpful in the subpoenas. I'm fascinated to hear this. The defense says, as stated above, counsel accepted service of 2 subpoenas directed at several of Combs's businesses in March 2024. I mean, okay. Those could have been just filed on corporate counsel. It says separate counsel for the entities filed a motion to quash these subpoenas in April 2024. In May 2024, upon becoming sole counsel in connection with the criminal investigation of Mr. Combs, we advised the court that it would withdraw the motion to quash the grand jury subpoenas and instead that the parties would meet and confer with the government to minimize the number of requests on which the parties disagreed. Counsel agreed to begin gathering documents responsive to the subpoena. So these are document subpoenas to the companies, and counsel for the companies said, no, we're going to move to quash it. It seems that Mr. Combs might be sole owner of the companies if his criminal attorney is able to take these things over without there being a conflict. Which also makes sense that the defense attorney would want eyes on what's being turned over from the companies to the government, knowing that this was going to be a RICO case, knowing that company records are going to be greatly involved. I'm not surprised that criminal counsel wants to see exactly what's going out the door. It goes on to say for the past several months, counsel for Combs and the AUSAs have had regular discussions about what documents we had, what we did not have, and in regards to the documents we did not have, where the government may be able to find such documents. We did this for 2 reasons. First, there was nothing in counsel's estimation that would constitute evidence of Combs being involved in a federal crime. Second, we wanted to be appropriately helpful to the government in its investigation. To that end, the Combs entities have produced over 144,000 pages of documents to the Southern District of New York in compliance with the subpoena. Right. It's a subpoena. You either have to fight to quash it or you have to adhere to it, or there's consequences. Then they talk about paying off the mortgage again. They talk about the legal standard that they would like the court to keep in mind, which is that liberty is the norm and detention prior to trial or without trial is the carefully limited exception from United States versus Salerno. It's a 1987 Supreme Court case. And then they go on to cite other similar cases. And then they get into the presumption of detention in sex trafficking cases and argue that the presumption is rebuttable, which means you can overcome that presumption. And they talk about what the defense needs to do to shift that. And the factors that we went over last week, the nature and circumstances of the offense, the defendant's history and characteristics, the danger to the community, which the government leaned heavily into. And because the government leaned heavily into the danger to the community argument, the defense also leaned into it. It talks about the March 5th, 2016 video from the Intercontinental in Los Angeles. They say that the government proffered one example for the court of Combs's exhaustive history of obstruction of justice. They say this obstruction related to an incident caught on video 8 years ago and attached the government's letter as Exhibit A. They say, however, the circumstances surrounding this incident, even in the light most favorable to the government, does not amount to obstruction. They say obstruction of justice requires that a person act corruptly and in regard to an official proceeding. Even under the facts proffered by the government, there was no official proceeding in fact or in the contemplation of Combs or anyone else. This event from 8 years ago simply is not obstruction of justice. They go on to say, second, the government argued that when the female depicted in the video filed a 35-page civil lawsuit in November 2023 against Combs, and Combs publicly responded by saying, I did not do any of the awful things alleged, that those denials were further attempts by him to obstruct justice and prevent the truth of this event from being known. Defense says, to be clear, preventing the truth of an embarrassing event in which Combs is caught on videotape in an alleged assault is not obstruction of justice. It does go to the racketeering, though, that protecting his brand and his image is part of the entire organization, but they are saying there is no justice to obstruct. And the government argued, of course, they were trying to bribe security guards, not Combs directly, but those with him were trying to bribe security guards and were trying to keep Cassie in the hotel room until she healed so she couldn't go report what had happened or wouldn't be seen publicly. They go on to close this section of their argument with the gravamen of the civil lawsuit was not misdemeanor assault, which is at most what is depicted in the recording, but sex trafficking. They then say he denied it then, he denies it now, he will deny it forever. There are very, very strong words still in Diddy's denials. It goes on to say contacting potential victims and witnesses. The government argues that Mr. Combs himself has contacted witnesses, including one who received a grand jury subpoena and at least one victim. They say again, this is not obstruction of justice, and the government does not point to any obstructive conduct. They say Mr. Combs is entitled to gather witnesses and defend himself against the government's allegations of sex trafficking and racketeering. They say as part of that defense, he, with counsel's blessing, that's new information, has called potential defense witnesses to let them know that counsel would reach out to speak to them. They say tellingly, the government does not point to, nor can they, any conversation Mr. Combs has had with a potential witness since he had knowledge of the criminal investigation where he pressured any witness to change their story. They go on to say instead, the government points to Mr. Combs' contact with a female member of the band called Diddy Dirty Money after the filing of a lawsuit against Mr. Combs by another female member of that band. As counsel stated at yesterday's bail hearing, this is the furthest thing from witness obstruction I can think of. They go on to say, and so someone in the exact point of view of a civil plaintiff comes forward and says, in essence, and this is, I thought it was a soft, respectful statement, and the statement was, I'm not taking away her experience. That wasn't mine. That wasn't my experience. She is entitled to her experience. I was there. That's not what I saw. That's not what I saw. That's two witnesses having divergent recollections of similar events. And I expect this trial is going to feature exactly that. So there is nothing wrong with that. And that's why we have criminal trials and civil trials. So the defense is citing back to their oral argument from the day before saying, but Your Honor, he was calling somebody who said that their experience was different than somebody who had sued him civilly, and that's all fine. The defense goes on to say the proposed package will address the government's stated concerns for witnesses. How? They say the government has further argued that detailed evidence of freak-offs in the form of travel records, communications, hotel records, witnesses, and videos. To be clear, the defendant's companies, through this very counsel, has produced many of those travel records to the government to punish the defendant for complying with process, specifically producing travel records because such records have corroborated witness stories is mind-boggling. How? The government subpoenaed documents. They say the documents support witness statements relating to crimes that happened, and those documents, which could otherwise be neutral, travel documents are just that, but it lines up when the company travel records show that people were in the same places and hotels they say they were, it corroborates witness and victim stories, but that's not punishing the defendant. That's the process. Also, you have to comply with subpoenas or there will be further consequences and then the information will be gotten anyway. So I don't know what's mind-boggling about it, but okay. They say the government further argues that their investigations have yielded evidence of numerous assaults against female victims and other individuals. The proposed package will address the government's concern here, as Mr. Combs will agree to not have any female non-family visitors at his house, and his security company will keep a record of all incoming and outgoing visitors. I think the contact is the concern by phone, by email, by just knowing that he's not in custody. They go on to say that what they have offered should address the court's concerns. The defense says before addressing the proposed conditions that relate to danger and obstruction, it is critical to note that every allegation in the indictment and every argument in the government's detention letter is being factually contested in detail. We are not merely making general denials of guilt. Rather, we are advancing detailed, specific facts that undermine the government's theory at its core. We will provide examples of this. First, there is one alleged sex trafficking victim in the indictment. One. They put that in bold. They go on to say the government can say what it wants, but what it is actually charged is one victim. Count 2, charging sex trafficking, mentions victim 1. There is no victim 2. That one person was in a 10-year romantic relationship with Sean Combs. That one person was an adult woman who lived alone, who never lived with Sean Combs. She had her own friends. She had her own life, as adults tend to do. He goes on to say Mr. Combs and this person were very much in love for a long time. This is exactly what they said in their oral argument. It goes on to say, as the many written communications between them show, this one person has expressed anger and jealousy because Combs had another girlfriend, as will be testified to by many witnesses and as the written communications show. They say at the end of Mr. Combs and this person's relationship, she started a relationship with her trainer, which prompted Mr. Combs and the woman to break up. But if it's the end of their relationship, isn't it already over? It goes on to say he did not force her to stay, but instead released her from any obligation to his record label. It goes on to say a month later, when the mother of 4 of Mr. Combs's children passed away, this person was present at multiple memorial services around the country to support him. This is not sex trafficking. Well, at least it's clear what the defense will be arguing. And they have laid it out. And they have laid it out again, exactly the same way they laid it out in their oral argument. They go on to say 5 years later, this woman hired a lawyer to contact Mr. Combs's lawyer. Mr. Combs's lawyer recorded the conversation, which lasted 8 minutes. The woman's lawyer said that the woman wrote a book. It would be a tell-all, that the book would be embarrassing to Mr. Combs. Her lawyer said that she would be meeting with book publishers to publish the book. However, if Combs wanted to buy the exclusive rights to the book, then he would own the rights and could prevent the book from ever being published. Her lawyer then said that in order to stop the book from being published, he would have to pay her $30 million. We heard this in the oral argument at the detention hearing. They go on to say when that clear extortion proved unavailing, the woman took another tack. She hired a lawyer to bring a civil complaint, taking advantage of an expanded statute of limitations for sex cases. They go on to say Mr. Combs settled the case. This was not because he assaulted or trafficked anyone, but because of the disastrous consequences a lawsuit of this nature would have on him and his business interests. Well, that was a civil lawsuit. It goes on to say, we are now in a position where the only person alleged to be a victim in count 2 extorted Combs on audio and profited millions of dollars. It says the precise settlement of the civil suit remains confidential. Well, that will unconfidential when all of this goes to trial, but for now, yes. It says we have countless written communications that tend to negate any lack of consent and any coercion. The evidence shows a long-term loving relationship that became strained by mutual infidelity and jealousy. The defense's theory of this case is really going to be that this was a long-term loving relationship. It goes on to say the evidence of this and this alone is overwhelming. There was no sex trafficking, there was no sex crime of any sort, and we will conclusively prove that at trial. If the presumption of innocence means anything, it means that when a proffered, detailed, factual defense is readily apparent, the court should reserve judgment and should wait for the facts at trial. Yeah, but this is a bail hearing. It goes on to say that all being said, we are willing to agree to significant conditions outlined as though Mr. Combs is a danger, which he is plainly not. As indicated above, we are willing to restrict visitors at his home. We are willing to ensure that he not contact known witnesses, and we are willing to have him undergo weekly drug testing, in addition to other conditions as outlined. And then it goes on to a review of other cases, and they talk about the Epstein case, Raniere, R. Kelly, and the Maxwell case, and why those cases are different, which we saw in the detention hearing as well when he said, but in this case, none of the alleged victims or individuals named under the RICO statutes are minors. It says that the bail package addresses issues with flight and danger to the community, and that Combs has never evaded, avoided, eluded, or run from a challenge in his life. He will not start now. He has handled every hardship. He will meet this case head on. He will work hard to defend himself, and he will prevail. They say recognizing that a bail hearing is not the time to defend on the merits of a criminal case, it is relevant to bail that the defendant has made a clear communication to defend an imminently defensible case. This is such a case. Do they not have all the video yet then? Or is there argument about all the video going to be that this was all consensual and that no one crossed state lines? Because that's not at all what's in the civil lawsuits. But in that 15-page filing, the defense simply goes through what their oral arguments were at court and says that they will have Diddy drug tested and ankle monitored and with personal security. And then they attach all of the breakdown about his Miami mansion. The government has some things to say in response, and we're going to look at that more briefly and in summary. What's interesting is how much of their defense the defense is signaling. I wonder how strongly the defendant feels about putting his version of how he sees this case out into the public, and if that's why they are doing that. But the government clearly knows what the defense is thinking, and so do the victims in this case. And I did say victims because even though there is one charged victim at this time for count 2, the racketeering counts are going to involve more individuals, even if they are not individually charged in count 2. The government says they respectfully submit the letter in advance of the bail appeal by defendant Sean Combs, aka, and then they list them all: Puff Daddy, P. Diddy, P. D. in love. And they say for the reasons set forth in the government's September 17th letter, they are incorporating that into this letter. They say the defendant presents a danger to victims and others, both through physical violence and through obstructive conduct, and a risk of flight. He must be detained. Additional background. They say that the relevant facts are set forth in their previous letter. The defendant was arrested on September 16th, arraigned on the 17th before Judge Tronovsky, and then held in detention on 3 grounds: dangerousness, obstruction, and risk of flight. They say pretrial services similarly recommended detention for the defendant. The government goes on to say after an extended bail argument, the court found that the defendant had failed to rebut the presumption of detention in this case. They say that Judge Tronovsky noted that the crime of sex trafficking is a crime that happens behind closed doors, and expressed further concern that such conduct could not be monitored by pretrial services. The court further found that detention was warranted based on defendant's history and characteristics, and then they quote from the transcript. There are also indications in your history and characteristics that I think are a reason why the presumption in favor of detention has not been rebutted. Prior substance abuse and the fact that the alleged violence seems to occur hand in hand with times when you are not necessarily in control of your actions because of that substance abuse. Your lawyer asked me to trust you and to trust him, and I don't know that I think you can trust yourself. And I don't believe that counsel has the ability to control you, given the significant concerns I have, particularly because of substance abuse and what seem like anger issues. They say, in addition, the court noted that the weight of the evidence is significant, given that the government has proffered that there were multiple witnesses who are saying that they have witnessed significant serious violence. Finally, the court concluded that the danger posed by the defendant was quite serious due to the defendant's access to weapons, use of violence, and coercion of witnesses. They say this court should reach the same conclusions. Judge Tronovsky's findings are well supported by the record before the court today and demonstrate why the presumption of detention is not rebutted in this case. Moreover, defense counsel's most recent letter fails to seriously contend with the findings most glaringly related to defendant's unpredictable dangerousness and inability to be monitored or controlled. They then talk about why he is an ongoing danger. They say despite public statements by counsel minimizing the defendant's conduct, both Judge Trinovsky and the media, the defendant has committed incredibly serious crimes. And then they cite an interview of the defense attorney on YouTube. They say, as alleged in counts 1 and 2 of the indictment, among other crimes, the defendant has used violence, threats of violence, and coercion to cause women to engage in commercial sex acts. In other words, the defendant committed sex trafficking, a crime so serious that Congress has determined that there is presumptively no condition or combination of conditions that will reasonably assure the safety of the community and the defendant's appearance in court. And then they go back through the same arguments they made at the bail hearing, saying that the defendant's repeated acts of domestic violence, which are reoccurrent and, as noted by Judge Trinovsky, often occur behind closed doors, are not disconnected to the offense conduct. They are an element of it. The physical force and coercion the defendant repeatedly used during and apart from the freak-offs caused the victims to engage in the sexual activity. That is sex trafficking. These acts of physical force, of violence, are corroborated not only through victim testimony, but also through, among other things, victim communications with the defendant spanning years of the charged time period, witness testimony, including witnesses who were present during and after the freak-offs, video footage, photographs capturing victim injuries, and law enforcement records, among other things. The same is true of defendant's coercion. The communications between the defendant and multiple victims, which include communications sent as recently as this year, capture victim resistance to engaging in freak-offs even in light of the defendant's abusive tactics. The defendant's years-long use of force and coercion speak directly to dangerousness. To be clear, despite the indictment naming one victim in count 2, this case is not about just one victim. The government's evidence to date, including the defendant's own communications, demonstrates that the defendant has used force and coercion against multiple victims. In addition to these women, the defendant has assaulted a host of other individuals, including his employees and witnesses to his violence. For example, the defendant directed his rage toward his employees and those close to victim 1 who had seen him physically abuse victim 1, including by throwing these witnesses against walls or onto the ground, choking them and throwing objects at them, among other things, particularly when they attempted to protect victim 1. In doing so, the defendant has demonstrated he is not only a danger to victims and witnesses, but he is also obstructive and willing to engage whatever is necessary, including physical violence, to instill fear in witnesses to keep them silent. All of this violence against witnesses, victims, and others factors into the analysis of the defendant's dangerousness. Then they talk about the obstruction, and they talk about the fact that Diddy was in contact with witnesses. They say defense counsel acknowledges that the defendant has contacted witnesses in this investigation, apparently with quote-unquote counsel's blessing, but claims that the defense has studiously avoided interviewing grand jury witnesses. The fact is, the defendant personally and repeatedly contacted multiple witnesses, including at least one he himself knew was a grand jury witness. The defendant contacted these witnesses, including at least one whom he had not been in contact with, for years after they were served and leading up to the date they were required to appear before a grand jury. The defendant's behavior illustrates Judge Trinovsky's point that counsel cannot control their client. Doesn't it sound Murdaugh-y? When Murdaugh was reaching out to people left and right as things were going down and was like, hey, Bo, just want to check in, see how you're doing. Sometimes it can be seemingly as simple as that if there is years of history behind it. Reaching out to someone who you hadn't been in contact with for years right after they receive a subpoena might have a different feeling than reaching out to someone after years after they had had something happen in their life. It's a bit different. And the government does not miss the opportunity to comment on counsel's attempts, in this case, to discredit victim 1. They say, finally, it bears noting that within the first 24 hours of this case's unsealing, there are already new concerns about witness interference, as well as interference with a fair trial based on the defense and his counsel's attempts to publicly discredit one of the victims. As Judge Tronovsky noted at her ruling, one of the pertinent concerns here is the power imbalance in the case. The defendant, as alleged in the indictment and publicly known, is a man of immense power and influence. Consequently, his ability to coerce victims and to influence witnesses is outsized. Just yesterday, during the bail argument and a subsequent appearance on CNN, defense counsel impugned the allegations made by a statutory victim, challenged the motivation and timing of her claims. In addition to being factually inaccurate, this sort of attack comes close to limits set forth in Criminal Rule 23.1. It's pretrial publicity. It also can be expected to intimidate other witnesses who may feel tremendous pressure not to go up against the defendant. The government therefore requests that the court caution defense counsel not to violate Criminal Rule 23.1, including by publicly challenging the credibility of prospective witnesses or by publicizing information counsel knows to be likely inadmissible at trial. Moreover, the government submits that this is yet another example of the defendant's ability to obstruct these proceedings, even through the media. And then they cite United States versus Bankman-Fried, remanding defendant who disseminated materials to the media in an effort to discredit and intimidate a trial witness. Remember when Sam Bankman-Fried from the SBF crypto disaster, remember when he disseminated a journal of his ex, who was one of the key witnesses in the case, and then got remanded into custody? He had been allowed to stay out, got remanded in because of that behavior. So it's a point well taken that the government's like, remember, Your Honor, this is what people get thrown into custody for, and he's already engaging in it. And the sass from the government continues. They're talking about the flight risk. Both at argument yesterday and in the press, the defendant has emphasized his supposed, quote, cooperation with the government, including his willingness to surrender. The court should take that argument for what it truly is: attorney-crafted theater designed to convince this court that the defendant can be trusted and is not a flight risk. Make no mistake, the defendant's recent behavior shows that he cannot be trusted or controlled, particularly now that he is facing serious charges that carry significant penalties. As Judge Tronovsky observed, quote, your lawyer asked me to trust you and to trust him. And I don't know that I think you can trust yourself, and I don't believe that counsel has the ability to control you. It said, indeed, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation. That is the information I have wanted to know this whole time. Thank you to the government. January 2024 is when they say that Diddy was unquestionably aware that this investigation was ongoing. They say the evidence shows that he has engaged in multiple freak-offs, some involving interstate transportation of individuals to participate. He has continued to use narcotics. He has contacted multiple witnesses. Some of this conduct, they say, has even taken place since the defendant arrived in New York City, allegedly to sit it out and wait to be arrested. The defendant's conduct is demonstrably not cooperative and indeed highlights his inability to abide by the law or counsel's directives. And then they go on to highlight why the law is on their side. They again talk about the Epstein case, the R. Kelly case, and talk about the new bail conditions don't adequately assure anyone that the defendant will change his behavior or not pose a danger to witnesses, victims, and others. And then their conclusion is that there are no conditions of bail or combination of conditions that would assure the defendant's appearance and compliance and safety to the community. And as we know, bail indeed was denied, but we did learn some interesting new information. One, we know the defense is going to continue to be in the media trying to discredit Cassie, trying to paint her in a negative light ahead of trial, and the government is trying to shut that down. We also now know that Diddy was aware of these investigations in at least January of 2024, 3 months ahead of the raids on his home. And yet, the government still confiscated like 1,000 bottles of baby oil and lube. He had 3 months. He was aware that they were investigating him for 3 months before they searched. What does that say to you? What that says to me is that he still thought he was untouchable. And that's really what the government is trying to convey in their letter to the judge. Interestingly enough, this is not the only place we're seeing the defense take this tactic and pursue these arguments. We need to talk just briefly about the civil cases. Thank you to our sponsor, Policygenius. Unfortunately, life can be unexpected and things can change quickly, but knowing that you have life insurance to take care of your loved ones or dependents can make a huge difference. And life insurance, like most things with adulting, you have to make a decision when the need is not urgent. So let me remind you that now might be the time to take a look at if you have adequate life insurance, or if you're planning on changing jobs in the new year, maybe you're going to lose insurance and want to make sure that you still have some coverage. Policygenius makes it easy to compare America's top insurers in just a few clicks, and they don't work for the insurance company, so there's no incentive to recommend one insurance policy over the other. And it's no wonder that they're the country's leading online insurance marketplace. With Policygenius, you can find life insurance policies that start at just $292 per year for $1 million in coverage. Some options even offer same-day approval and avoid unnecessary medical exams. It's always a good time to plan ahead, so take a few moments and see what insurance policy is right for you. Head to policygenius.com or click the link in the description to get your free life insurance quote and see how much you can save. That's policygenius.com. Let's get back to today's episode. The Cassie civil case I covered was probably the most covered of all the civil cases I covered. We knew that was settled a day after it was filed. That case, a lot of those allegations give light to what's going on in the RICO charges in the criminal case. Then there's the Little Rod lawsuit. That lawsuit was filed February 26, 2024. It is back in court for a sanctions hearing against Little Rod's attorney that now some of the dismissed defendants are asking for, and that is the Universal Music Group defendants. A number of them have been dismissed out on a second amended complaint, and they are asking for sanctions against this attorney, arguing that the reason they were all dismissed out of the case is because they had no connection to the case in the first place, and they were only put in there to gain headlines and slander their names and their companies. So that will be coming up for that hearing. But Diddy also filed a motion to dismiss. We'll take a look at where those arguments are going in just a moment. And then there is the ongoing lawsuit against both Christian Combs and Diddy. Services being perfected in those cases. That's an LA County case. Because it's an LA County case, it's going to move fairly slowly. I imagine some of these will end up pausing as to Diddy now that he's been arrested. So we'll see if that happens. That hasn't been filed in any of the cases yet, but I'm tracking it. I expect that we will see Diddy's lawyers in some of the cases saying, our client can't help us with the civil cases. We need to pause them till the end of the criminal cases. And then we have the newer filed from September 10th, 2024, Dawn Richard lawsuit. We haven't covered that civil suit yet. I haven't broken it down yet. It has 21 different causes of actions. That is a federal case filed in New York, but we heard about it in the detention hearing. I talked about it last week and about this case shaking up some of the behavior of Diddy and reaching out to other members of Danity Kane to talk to them about what their experiences were, whether they were still on his side, as we heard in the detention hearing. But in that case, we are at the very earliest stages. Everyone hasn't even been served yet. So that case might run into some hurdles trying to serve Sean Combs, but a fleet of other companies are also being sued there. So I, again, will keep an eye on that case and see how it progresses. Some of these things are going to slow down because of the subsequent arrest of the defendant. But I want you to tell me how the response in the Little Rod lawsuit has aged for you as we take a look, not at all of the legal arguments, at the factual allegations in this motion to dismiss. It is a 33-page motion to dismiss. We will get into it when the court rules on it, and we will take a look at it a bit more. But this is a brief look at Diddy trying to dismiss the Little Rod lawsuit. And this was filed at the end of August 2024. This is their preliminary statement in which they say, quote, Jones's second amended complaint is his third attempt to dress up a run-of-the-mill commercial disagreement as a salacious RICO conspiracy. Running to nearly 100 pages, it includes countless tall tales, shameless celebrity name drops, and irrelevant images. Yet, despite all its hyperbole and lurid tactics, the Second Amendment complaint fails to state a single viable claim against any of the Combs defendants, and that's Sean Combs and his companies. It says that it is replete with legally meaningless allegations and blatant falsehoods. The SAC's true purpose is to generate media hype and exploit it to extract a settlement. No surprise, given that Jones's attorney was recently referred to this court's grievance committee for engaging in a, quote, pattern of, quote, improperly filing cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly, footnote 3, and then it cites the case. It goes on to say, taking a page from his attorney's playbook, Jones recently posted a video on X, which he, together with a performer known as Uncle Murda, laughed about this lawsuit despite his allegations of severe emotional distress, demanded Combs pay him that money by Monday, and warned, I'm from Chicago, we don't play about our business. The footnote then goes on to link the video and detail that they were at a public event hosted by 50 Cent. I don't know. I think the reference is referencing back to 50 Cent's beef with Randall Emmett, who was dating Lala Kent, if you're in my Vanderpump world with me, where 50 was like, get me my money by Monday. I don't know if that is a common 50ism where he tells multiple parties, not just Randall Emmett, to get him his money by Monday. I remember the Vanderpump memes. So part of me has to wonder if this was for the meme. I will caution, because lawyer, that as much as for the meme might be delightful in the moment, it is going to end up in court like it is now, with a footnote lining out everything that they said, want that money by Monday, talking about suing Diddy for all that bread, my boy wants a check, and linking back the video. Everything said during litigation will come up. Everything done during litigation will come up, especially in civil litigation. It goes on to say that, like the Second Amendment complaint, Jones's videotaped threats on social media are part of a calculated effort to promote his personal brand and profit from the exposure. Such tactics have no place in federal court. They go on to say the RICO claim must be dismissed because the Second Amendment complaint does not establish standing to sue, fails to plead a pattern of racketeering activity, and fails to plead the existence of a RICO quote-unquote enterprise. Well, I wonder if they're going to go take a look at the federal indictment and file a third amended complaint. Just a thought. Just wondering when that's going to happen. They go on to say that the Trafficking Victims Protection Act must be dismissed because the second amended complaint fails to allege any facts from which a plausible inference can be drawn that threats of force, fraud, or coercion were used to compel Jones to commit a commercial sex act, or that Jones is a victim under the statute. And then they get into the other causes and say things like Jones's baseless attempt to hold Combs liable for alleged sexual advances of third parties on a premises liability theory must be dismissed because he fails to allege facts showing that any claimed assault was foreseeable by Combs. Well, again, I wonder if they're going to go back to the 1,000 bottles of lube and the hundreds of recovered dildos and everything unearthed in the federal indictment and say, yeah, it was foreseeable by Combs because that was the environment that was not only fostered, but intended. That was the desired outcome for Combs. And then they start getting into breaking down the complaint line by line. I go over this to say that the fervor with which the defense argues against the Little Rod lawsuit maybe loses some of its wind in its sails when you take it in connection with the newly unsealed federal indictment. And this was from August 26th. That federal indictment came down September 12th, was unsealed September 16th. So, in quick succession to this response, I'm curious to see how the civil plaintiffs use what was unearthed in the federal indictment in their allegations in the civil lawsuits, because we will see some intermingling, especially when it comes to things like, was this foreseeable? Well, now here's this other pattern of behavior that's been unearthed by the federal government. So that pattern of behavior is going to get alleged here, especially when it goes to Little Rod's racketeering claims. And yes, you can bring civil racketeering. How much will this help at the end of the day? Will it help Little Rod get paid at the end of the day? Will the different plaintiffs in the civil suits want to settle their suits if they are also a part of the federal lawsuit? Because Diddy's defense counsel has signaled so strongly that any settlement will be used against them in court, or he will try to use it against them in court. I wonder if that signaling will discourage the civil plaintiffs from wanting to resolve their lawsuits, even though these types of suits are tremendously expensive. Will it discourage them because they're seeing the way that Cassie is already being attacked by Diddy's defense attorney? It will be interesting to see where this goes. I hope that all of those that have civil lawsuits or have had these experiences feel somewhat vindicated by the indictment, that at least all of the digital evidence has been unearthed. And I imagine there are many that are very concerned about what that digital evidence has unearthed and what will continue to come of it. Will there be more indictments, as the U.S. attorney seemed to suggest in his press conference last week? Will those be individuals that were part of the music label, part of not just Bad Boy, but higher up in the music labels? Will we see this be more wide reaching? Will there be continued fallout from those that were attending the Diddy parties? Did they know what was actually happening behind the scenes at these parties? And who knew? And how did they know? And what will the digital evidence show? And how many people knew what was going on and said nothing? And will they end up a part of this RICO case too? Or are there people who know they might be on those videos going directly to the feds and talking to them first, hoping that they can tell the feds everything they know without the long arm of the law getting turned back around on them? So who's running to the AUSAs to tell them what they know? And are we going to see anyone starting to speak in the media that are the high profile friends or former friends of Diddy about what they knew, what they saw, and what they wish they did differently? Or are they waiting to see where the dust settles? We're going to keep an eye on this one. Let me know your questions. Thank you for being here. Thank you for being a Law Nerd. Say it with me. May your Wi-Fi be strong, at least stronger than a travel recording at a hotel. May your toilet paper be plentiful. May your family be well. May your fall weather start to be cool and crisp. And may the odds be ever in your favor. I look forward to seeing you on stream this week, and I will talk to you in the next one. Bye. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.